Hello my dear friends and welcome to StudyIQ. I am Joy and today in this lecture we will discuss about the enforcement of unconstitutional laws in India. First of all, let us analyze the current affair. Many of the Indian laws continue to be implemented in the country despite being declared unconstitutional by the judiciary. So, the judiciary of the country is the custodian of the constitution. It is the guardian of the constitution. So, any law that is made in the country, whether it is constitutional, whether it complies with the provisions of the constitution or not, it is decided by the judiciary and it is done by a mechanism called judicial review. So, under the judicial review, the judicial system of the country decides whether a law that is existing in the country or that is made in the country is complying with the provisions of the constitution or not. Now, what is the current affair? Many laws that continue to be implemented in the country, they are declared by the judiciary as unconstitutional. So, when a law is declared as unconstitutional by the judiciary, it should not be implemented in the country because it does not comply with the provisions of the constitution or it is against the constitution. But in reality, in the country, many of the laws that are already declared as unconstitutional, they still prevail in the country, they still continue to be implemented in the country. So, we will analyze what are the reasons for such incidents or such implementations in the country, what are the solutions, and also we will analyze some recent examples wherein which unconstitutional laws are implemented in the country. Let us start. First of all, let us see some recent examples where some laws that were made unconstitutional or declared as unconstitutional by the judiciary but they are implemented in the country. First example is Section 66A of the IT Act. What is Section 66A? Section 66A provides punishment for sending offensive messages through communication devices. So, these messages may be any information that is created, transmitted or received on a computer system, resource or a device including attachments in the form of a text, image or audio or any video. So, what was the case with 66A? In the year 2015, the Supreme Court of India had struck down the Section 66A of the IT Act. The Section 66A of IT Act 2000 was declared as unconstitutional in the year 2015 by the Supreme Court of India. And this decision was made under the Shreya Singhal versus Union of India judgment. And this judgment was appreciated by the foreign as well as the domestic media very much. But what happened later? This judgment of the Supreme Court was in the year 2015. Even after making the judgment saying that this provision is unconstitutional, the Muzaffarnagar police in Uttar Pradesh, they arrested and detained a person for allegedly committing a crime under Section 66A. That is, he was alleged of the offence that he posted some comments on the Facebook, and this happened after 2015, that is after the Supreme Court made this judgment. This is just one example. If we look at the media, we will see that various medias reported that many other instances had happened where 66A has been invoked by the police. So what is the problem here? The Supreme Court of India, the judiciary is the guardian of the constitution. So Supreme Court has made some law unconstitutional. It means it has declared that some provisions of the law does not comply with the constitutional provisions. So Supreme Court on one hand made it unconstitutional, but the law and order system, that is the police, they have used the same section of the IT Act in order to arrest and detain a person. So this points to a serious concern of implementation of the verdict. So this verdict was not implemented in its true spirit. That is what this incident points out. So from this example, it is clear that the police still jail persons under unconstitutional laws. So this shows that there is a tendency of some laws to inhabit the Indian legal system even after their legal deaths. So, Supreme Court has made it unconstitutional but they still exist. Another example is the Section 303 of the IPC. The Supreme Court in Mithu versus State of Punjab case had struck down the Section 303 of the Indian Penal Code as unconstitutional. So what is section 303? 303 provided for a mandatory death sentence for offenders serving a life sentence. But what happened later in the year 2012, even after many years the Supreme Court had struck down the section 303, the Rajasthan High Court intervened to save a person from being hanged for being convicted under that offence. So from these two examples, it is evident that even after the judiciary declares some laws as unconstitutional, they are implemented in the reality. So now we will examine what are the reasons for this. The first and the primary reason for this poor enforcement of judicial declarations is the signal failures or signal differences between different branches of the government. Let us take for example judiciary, executive and the legislature. So judiciary once makes a declaration, it must be properly communicated to the executive and also to the legislature. In these cases, for example, let us take section 66A. The judiciary has declared section 66A as unconstitutional. So what is the role of legislature in this? The legislature will have to issue a statute declaring this law unconstitutional. So this has not happened. Why? Because there was a lack of coordination or communication between these branches of the government. So one primary reason is that there is failures between different branches of the government in communication and coordination. Second one is active non-compliance of the judicial declarations. Even after the judiciary makes such kind of declarations, it is clear that they are not complied to. The reason is that the other organs of the government like the executive or the legislature doesn't make sure that the final decisions are enforced. So that is the reason. Now third one is the lack of communication. We will see that there is no official method for sharing of information about such decisions. Now when the Supreme Court has made some declarations, there is no official channel in order to share this information about those decisions. For any bureaucratic structure to survive, it needs a working communication channel. There is a hierarchy properly defined in a bureaucracy. So this hierarchy needs to be empowered with the proper communication channel. The decisions that are taken up by the higher courts or higher authorities, it must be properly communicated to the lower levels of the organization. Another reason is the amendment of statute by the parliament. So Parliament is not amending a statute to remove the provision that is declared unconstitutional. So the law making body in the country is the Parliament. So if a law that is made by the Parliament is declared as unconstitutional by the judiciary, the Parliament has to take steps to amend a statute in order to declare the law as unconstitutional or void. Unless the Parliament does so, it will continue in the statute book. If we take the examples of section 66A of the IT Act as well as section 303 of the IPC, we will see that they still continue to be on the official version of the statutes published in the Indian Code. So they are still present in the statutes. So this has to be removed by the Parliament. And that is one major reason they are still being implemented in the country. Another reason is the lack of notifications. The government officials should consult notifications and circulars that are issued by the relevant ministries. So this is how this information can be passed. These notifications will help in sharing the information in an official manner about the judgments that has declared some provision as unconstitutional. Now what is the issue with notifications? This issuance of the notifications is not mandatory. And because they are not mandatory, there is no means to ensure that these notifications are issued. And there is also an absence of a formal system for information sharing. There is a hierarchical setup in the Indian judiciary. We have the Supreme Court on the top, we have high courts, we have lower courts. So there is a proper hierarchy set up on the Indian judiciary. But there is no formal system on communication sharing or information sharing in this hierarchical setup. But there are few exceptions in some high courts and district courts. So when a high court passes an order, proper circulars are issued to the district courts. There are few exceptions, but altogether if we take the case of Indian judiciary, there is a lack of formal system for information sharing. So all these reasons make the implementation of unconstitutional laws in India. Now what has to be done? What is the way ahead? we have seen that the Indian judiciary does not have the authority to enforce its own decisions. For example, the Supreme Court declares a law as unconstitutional, but after declaration it doesn't have the authority to enforce the decision. So what has to be done? There is a need to avoid human error in enforcing judicial decisions. And the implementation of such unconstitutional laws is a denial of the right to life and personal liberty of people. How? Because they will suffer the indignity of lawless arrest, because the law has been declared as unconstitutional by the judiciary. Now there is no such law, but those people who are arrested and detained will stand to lose their rights. So what should be done? There is a need to move from a system where communication about judicial decisions is at the mercy of the officers. There should be a proper communication system. So the decisions of the judiciary must be properly communicated within the judiciary and also to other organs of the government. You can find the PDF of this lecture on my Facebook page, and for any queries related to your UPSC preparations, you can get in touch with me on my Facebook page. I wish you all a very good day. Thank you.